welcome. This week, the firm is in full battle gear because on the show this week, the warfare continues. After a formal split in the Reliance empire in 2005, you'd think the Ambani brothers would have found some peace. Instead, they've been making frequent trips to court as Mukesh Ambani's Reliance Industries battles Anil Ambani's RNRL over a gas supply contract. Now, interestingly, last week, Reliance Industries lawyer Harish Salve is reported to have called the Ambani family agreement trash and emphasized that it was only between the two brothers. Was he implying that agreements between members of promoter families are not binding upon their companies? Well, in that case, how can you make a family agreement stick? And when will it not stand up in court? Isha Dalal finds out.
It's an epic battle. Blood relatives pitched against each other to defend their own territory. And things are no different in the 21st century. 2004 saw the Ambani brothers locked in a corporate war for the $22.5 billion Reliance empire. A war that caused division of the company and is now back with a vengeance. In the family agreement, Mukesh Ambani promised to supply natural gas extracted by his company RIL to Anil Ambani's RNRL. That promise is now being tested in court. More importantly, the government, a partner in the gas field, has jumped into the battle, claiming that the family price is too low and that the legal delay hurts government profits. So stakeholder rights must be taken into consideration, especially for public listed companies.
Private contract between the families is never brought onto the board of the company, is never brought in front of the shareholders, and what is given to the company and what is given to the shareholders is only a small, only a portion of it which affects the shareholders' rights and not otherwise. The result is that many times private contract, when it is sought to be enforced against a publicly listed company, it becomes very difficult if not impossible.
Provisions like non-compete clauses agreed upon by members of a family while demerging may diminish value for shareholders who invested in the consolidated company.
From a corporate governance and a shareholder rights point of view, even a shareholder could question something like this or an arrangement which is going to have an impact on the shareholder. And again, under company law, you also got provisions for mismanagement and oppression, where a 10% shareholder can actually go to the company law board and claim that this is not right and this is not good for shareholder value.
But shareholder value aside, such non-compete clauses entered into by promoters on behalf of their companies may not even be enforceable in law.
Section 27 of the Contract Act essentially states that any agreement in restraint of trade or restraint of carrying on any business would be void unless it falls within one of the exceptions. So any non-compete clause by itself, unless it is connected with, say, assignment of a business as a going concern along with goodwill, etc., would not be enforceable.
Enforceability comes into question also due to changing business conditions. Contracts must keep step with the future.
Brother A is now setting up, say, SEZ, Special Economic Zone. Now, in that zone, I can do anything that I want, notwithstanding the fact that I have agreed to not enter into a similar activity at all, because that activity is handed over to Brother B. Now, when Brother B points this out, that how can you do this, what I say is, look, when we signed, there was no mention about SEZ. I am going to do this in SEZ, where you are not there. So there are ways and ways of getting over this problem.
If there is a significant business change between the date of the execution of a settlement until the date when the settlement actually becomes operational and effective, so assume there is a 6-month or a 1-year time lag, and if there is a significant change in that interim, then there should be a right to maybe renegotiate or to better terms at that time if somebody is going to be unjustly enriched, by virtue of that.
Time changes business plans and also valuations. The takeover code does permit share swaps between promoters, but with fluctuating markets,
some of the transfers which were intended to be done, which were held by companies, cannot be done at the original rate. Or B, people have second thoughts on the values that have been ascribed to each unit.
So it seems that family agreements do time and again end up in court despite best efforts by both parties. But fortunately for them, it seems that Indian courts of law tend to honor the spirit of family agreements, even though these might not be in keeping with the letter of the law. But what's the golden rule to avoid these situations?
To preempt a possible problem, this would be an ideal scenario, that have as many companies as you have brothers or as you have children.
All right, it's a wrap on this edition of The Firm. We'll be back the week after next. Meanwhile, you can stay in touch with us by writing to firm@network18online.com. See ya.